For those joining us for the first time, welcome. The Cyberjustice Lab is a research center that explores the interplay between new technologies and the law. We're currently conducting the project Autonomy through Cyberjustice Technologies, funded by the 2017 Competition of Social Sciences and Humanities Research Council of Canada. Our project brings together more than 50 researchers and 45 partners dedicated to the use of technologies and artificial intelligence for the prevention and resolution of conflicts. Over the coming months, the Cyberjustice Lab will be hosting a series of online activities that will gather the opinions and experiences of legal experts from around the world. From ethical issues to crisis management, the lab will present a various and relevant content. Stay tuned by checking our social networks and visiting our website at cyberjustice.ca. Today, we welcome Shannon Salterd from the Civil Resolution Tribunal, Daniel Rainey from Holistic Solutions, and my colleague, Mark Likhten from the Cyberjustice Lab. We will start by a presentation from Mark Likhten on the online dispute resolution platform the Cyberjustice Laboratory recently launched in collaboration with Commission des normes, de l'équité, de la santé et de la sécurité du travail, CNESST. The CNESST is the Quebec public body overlooking questions of labor standards, pay equity, and occupational health and safety. It will be followed by a discussion with our panelists on the challenges related to implementing ODR initiative for disputes in labor law. Mark, over to you.
Thank you, Maggie. And first of all, I would like to thank everyone, our panelists and the audience for joining us today for this virtual discussion. I'm just going to share my screen right now for my little presentation. Yeah, so like Maggie mentioned, well, my name is Mark Likhten. Like Maggie mentioned, I'm a lawyer at the Cyberjustice Laboratory. And I wanted to tell you a little bit about the very recent project we launched with the CNESST. I'm going to call it CNESST, which is the acronym in French. But the platform itself is called PARL CNESST. And the CNESST is the Commission des normes de l'équité, de la santé et sécurité au travail, regulating a big chunk of labor questions in Quebec. So first of all, why is it called the PARL platform and what is PARL? So PARL is the platform that has been developed for many years now at the Cyberjustice Lab. It's the core platform that is behind the different solutions that we provide to different partners and organizations for ODR processes. PARL obviously is the French word for speaking, but it's also an acronym for Platform to Aid in the Resolution of Litigation Electronically. When I say we have implemented it in the past, here are only a few examples of where the PARL core, I would say, was used. So Mediation is a platform developed for French bailiffs in France. It has been working for many years now. And it's very interesting actually about this one is that we have developed a parallel platform, which is called Urgence Mediation with Mediation as well, and which is designed specifically for conflicts that have arisen from this COVID crisis that is ongoing. And it has received pretty good press. So the two other examples, the CAT is the Condominium Authority Tribunal. It's a fully online tribunal in Ontario for condominium disputes. And the Office de la Protection du Consommateur is the Quebec Office for Consumer Protection. It's a platform that is also based on PARL, on the PARL core. It has been also working for more or less 5 years now, and it has very good response rate, with a settlement rate of approximately 70% and a user satisfaction rate of 90%. So if we go to PARL CNESST, which is one of the most recent projects, it was launched in February 2020 of this year, so very recently. And it's also based on Parle, but I would just have to point out here that it's not a one-size-fits-all approach when we're speaking of Parle. I would even say it's the opposite. Yes, Parle is the core software behind the platforms, but for developing, let's say, the CNESST platform, we gathered around the table the experts of the lab, the technical expert, the legal experts, representatives of the different stakeholders, of the employees, of the employers, and so to develop this platform that would respond to the needs at the maximum level possible. The CNESST was initially not offering mediation for all of its jurisdiction. It was already limited to specific types of cases. And to launch the platform gradually, we went with these two types of cases, which pertain to the labor standards and which are unjustified dismissals and prohibited practices. Nevertheless, if we look at the numbers, these two issues, they make for around approximately 35% of the labor standards complaints. And I'm sorry, I only had the numbers for 2018, but I presume they must be kind of similar. So 35% is still a pretty significant chunk. And I have the numbers as well from March 30th, 2020. For 6 weeks of using the platform, there were already 42 cases on the platform. We expect these numbers to grow exponentially, not only because of the COVID prompting everyone to try to go online as fast as they can, but also because the health crisis, the COVID crisis, is creating a lot of employment disputes. I'm just gonna resume a little bit how the platform works. The process is pretty standard ODR process. It starts with a filtering phase. The complaint is made by the employee or the claimant, and it's validated by the CNESST. During the whole process, you have online help with guides and pathways for the users to help them use the platform. And then it goes to negotiation, mediation. And if the parties find an agreement, hopefully, then the agreement is generated in the platform as well, downloadable, and validated by a mediator and legally validated. So just before finishing, and I wanted to show you a few of the interfaces of the platform so you have a good idea of how it works. Like I said, the first step is the file creation process. It's done by a CNESST clerk usually, and it's pretty user-friendly. File number is assigned. I'm sorry, it's in French. The platform is actually available in French, English, and Spanish, but I only had access to the French interface, but it should be still understandable, and I'm going to explain it in any case. So after the file is created, it goes to the file completion phase. The file completion consists of the employee or the claimant making the first settlement proposal. As I said, in gray here, you have a little bit of instructions and guidance on how to do it. And also, they can contact a mediator right from this step. And at this point, the mediator is not acting per se as a mediator, it's acting more as a resource person to whom the party, not even the parties, the claimant can ask questions or seek for guidance. And the first proposal, settlement proposal, is also verified by the mediator before being sent to the employer. Then if the employer joins, because we have to keep in mind that the platform is voluntary, it's on a voluntary basis. When the employer joins the case, the parties are invited to negotiate. They exchange offers and counter offers. And at any point at this stage, any party could request the intervention of the mediator and thus go to the next phase of mediation. The mediation here, you have a forum where the mediator intervenes. They can exchange messages. The parties can also agree to do a conference call, video conference call, which are treated on the platform of their choice, but then not happening on the specific platform of CNESST. And like I said, when they reach an agreement, the agreement is downloadable in PDF format. It's validated by the mediator, and usually most of it is pre-populated with the legal appropriate wording, and the parties then have to accept it the last time. So like I said in the beginning, we have the chance today to have a world-renowned ODR specialist with us, and I would like to give it to Shannon now, who will present us a little bit how the CRT is working, the Civil Resolution Tribunal, how they deal with issues like this. So over to you, Shannon.
Great, thank you. Is everyone able to see my screen? Excellent. Thank you very much, Mark. I've been following Parl's advances over the years, and it's really exciting to see it now be applied in so many different contexts. What you're about to see with the CRT, and I'll just take 5 or 10 minutes to give you an overview, because I know we all really want to hear from Daniel and get to the discussion, but what you'll see is a lot of parallels between what Mark has shown you and what the CRT has adopted. And all of this, of course, is built on the founding work that Daniel and others have done over the years, building on their thought, their experimentation, and it's very exciting to see so many applications now popping up around the world. The Civil Resolution Tribunal is itself an administrative tribunal, and so what I'm going to show you is how we use technology. So we have a platform, but it's also an entire entity itself that uses and is based on online dispute resolution. As an administrative tribunal, or as Americans refer to it, an administrative court, we're part of the public justice system. So our process culminates in effectively a court order if people have to go all the way through to adjudication. But like Parl, we really try to focus on collaborative dispute resolution wherever possible. And we have a very wide area of jurisdiction. We began with condominium disputes in 2016. And then every year since then, our jurisdiction that we've been given by the legislature in British Columbia has grown. So it grew to include small claims under $5,000 a year after we opened our doors, then most motor vehicle personal injury disputes, then societies and cooperative associations. So these are like nonprofit associations. And then in February, the government announced that we'd be taking over effectively all motor vehicle disputes in the province. So started really small and just kept on building and building. And what we found, and this is relevant to our discussion over labor and employment matters, is that if you do a gap fit analysis, which is what we do every time we're given a new area of jurisdiction, so we look at that new area and we compare it to our process, which looks like this, and we try to identify where these new kinds of disputes are not going to fit well within our existing process. And the good news, and this is probably good news as well to people like Daniel who've been thinking a lot about this for so long, is that what we found is that the ODR process that Mark described works really well for quite a wide variety of disputes. So some of the disputes that we handle in our small claims jurisdiction do involve employment. We have a separate tribunal in British Columbia called the Employment Standards Tribunal and the Employment Standards Branch, which handle most employment matters. But there are some kinds of employment matters that are outside their jurisdiction and within ours. So that makes it a bit confusing for the public, and I'll get to that in a moment. But despite the fact that employment disputes are very different from condominium disputes, which are also very different from car accident disputes, what we found is that this basic process seems to work well for these very, very different kinds of disputes that are different not just in terms of the law, but they're different in terms of the amount of money at stake and the relationships between the parties and the amount of evidence and complexity. And I'll get to that in a moment as well. But basically, for all of these very different kinds of disputes, people start the same way through a solution explorer, an expert system that asks them questions about their problems and then uses their answers to give them free legal information. And we also, in that process, give people tools like letters they can send to their employer in the employment context, or letters they can send to a neighbor or to an insurance company to help them solve the problem on their own. So we give them free legal information and then resolution tools, because our best case scenario is that they don't even file an application for dispute resolution with us, never mind having to go to court. Our best case scenario is that they're able to resolve the dispute themselves, because that will be fast and it won't cost them any money. So for employment disputes, one of the ways that we use this first green box, this solution explorer, is to give people information about whether their employment dispute is even something we can solve, or whether they have to go to those other tribunals I talked to. So that's sort of the filtering function as well that Mark talked about. After that, people can seamlessly apply for dispute resolution using an online form. We take care of notifying and serving the other party in the dispute. And then when the other party comes into the process, the parties are invited to negotiate using a platform very similar to the one that Mark showed us. That resolves some disputes, but often we find a mediator has to be involved. People need human help to assist them. And that's when one of our mediators will help the parties reach an agreement if they can, either using our online platform, but often also using telephone or video conferencing as well. We are predominantly an online tribunal, but we also offer multi-channel service. And that's one of the ways that you can get around the common objection people have to ODR, which is that not 100% of people are online, and so we shouldn't do ODR. It doesn't make sense even on its face, that argument, but it is true that there are some people who don't have access to technology, and it's important to give them other ways of engaging. So the key here isn't just about using technology, it's about being really flexible and bringing the justice system to where people are. And for some people, that will mean that they're best served with in-person help or with telephone help, for example. So the mediation phase resolves a huge percentage of our disputes. That percentage is different though, depending on the dispute type. What we find is for condominium disputes, those tend to be a bit more emotional and a bit more entrenched, and they resolve a little less often than small claims disputes, which are often very transactional, something somebody bought that doesn't work, for example. But nevertheless, overall, a very high resolution rate. The very small number of disputes that don't settle are sent to adjudication, where one of our tribunal members considers the evidence and the submissions and makes a decision which is binding as a court order. And people can submit their evidence and their submissions from their smartphone. And in fact, all of this can be done from your phone on your couch, including receiving the court order and the decision at the end. This is what the platform looks like. It's meant to use responsive design so that it just looks good on a smartphone without having to download any apps. Everything we write is at about a grade 6 reading level. That is particularly important for small claims, where we get applications from people from every background, every walk of life. A lot of people in British Columbia don't speak English as a first language. But in my view, that's also an important consideration, even if your tribunal or your service is meant to serve people who do have a high level of education or English ability, because legal stuff is complicated. And to the extent that we can make it really simple by using careful, understandable language, that's going to help everybody. This is what the Solution Explorer looks like. So quite similar to what Mark showed you in Parl, where people can basically answer questions about their problem, and then we give them free legal information and tools like a template letter. This template letter is something you can use on your smartphone as well. You don't need to have Microsoft Word. You can just, it's already written for you, so you can enter your own information and then send it to the person that you're in a dispute with. And I mentioned after the Solution Explorer part, the question and answer part, people have a chance to negotiate. And what we have found, though, is that not that many disputes resolve through pure negotiation. Oftentimes, by the time somebody has gotten to this stage, they need a human to be involved. Our negotiation process is voluntary. People don't have to use it. But we do use some behavioral economics and behavioral insights to try to nudge people towards talking to each other. We find when they do start talking to each other, the resolution rate is a lot higher. Mediation, though, is mandatory. So people don't have to negotiate, but they do have to participate in mediation in our process. Unlike a lot of court processes or even mediation programs that are part of court processes, a lot of what we do is really focused on mediation. It's not focused on the judge or adjudicative part of the role. A lot of what our tribunal members do is give effect to the mediation process, strengthen it and support it by making orders for people to participate if they're not doing that, making orders that they behave in a respectful manner, making orders that they adhere to deadlines set by the mediator. So again, that's very, very flexible. And if parties are able to reach an agreement, that's also turned into a court order so that they can enforce it. All of our staff works remotely, including all of our tribunal members now. Before the pandemic, about 75% of our staff and members were working remotely, but we pivoted to make that 100%. And that's allowed us to kind of uniquely, at least in British Columbia, stay open while all of our courts initially shut down almost entirely and are still largely not operational except for urgent matters. Meanwhile, we are continuing to operate normally throughout this time, and that's been, I think, a real source of pride for our staff and our members. So our hearings are primarily through written material. People submit their evidence and their submissions, and we look at that electronically. We do have oral hearings via Skype where that's necessary, and all of our members have training in terms of how to run a hearing that way. And our decisions are published on our website using the same technology that powers CanLII. Full disclosure, I'm on the CanLII board, so I'm definitely biased, but I think it's really important to have a search engine that's highly usable, that allows people to have information about how the tribunal makes its decisions. And so that was really important for us from a design perspective. And then just to close out, we survey people who have gone through the process, and like Parl, we have very high satisfaction rates. I think this is a product of having a tool that's used human-centered design, that's been rigorously tested primarily with community legal advocates to make sure it works for people with barriers. And we don't ask people if they agree with the outcome of their case. Our decisions are subject to judicial review, but we do ask them if they feel that we treated them fairly, if they would recommend it to others, if they understood what they had to do, and so on. And that's been a really good source of ongoing user testing, because we take the comments that we get as well and use that to improve over time. So I'll just close out by saying that although this is about online dispute resolution, I think that that's really secondary to something that's far more important, which is using human-centered design in all aspects of our justice system. So we sometimes get asked a lot, well, ODR works for small claims, but it doesn't work for labor, or it won't work for complex securities disputes, or it won't work for landlord-tenant disputes, or whatever it is. And it's usually the people who are usually saying it won't work for X is usually the area that they practice in. And so I think we have this idea that what we do as lawyers could never be altered through a process like this. And of course, that's just not true, or at least we don't know if it's true. And so my view is that online dispute resolution is not the solution for every access to justice problem, but human-centered design is applicable to every part of the justice system. And where that may lead you is towards ODR in some cases, and it may lead you towards other processes in other cases. But the key is viewing the problem from the perspective of the person who has to navigate it. And so in my view, the ODR part of what we do is secondary to a lot of these analog things that you see on the screen that were the product of working with community legal advocates to understand their client need better. And so a lot of what they've told us about what their clients need include things like cultural competency training for members and staff, mental health training, having free telephone interpretation, having plain language. I didn't show you screens about this, but we ask if people need special accommodation along the way due to mental health issues or visual or hearing impairments, for example. And so a lot of it is this human-centered part. I will just end by saying that I think there are special considerations with ODR when you're considering applying it to circumstances where people have ongoing relationships or have had close personal relationships, as you often find in employment cases. What we find in cases where there is that ongoing relationship or that kind of emotional connection, and primarily in our condominium disputes, is that they can be more complex to resolve. They can require a greater degree of mediation, a greater degree of human effort. But to my mind, those are all good reasons why those disputes are excellent candidates for ODR, because ODR gives you the opportunity to have those multiple asynchronous touch points, to focus on collaborative dispute resolution, to try to preserve people's relationship where you can, and also give effect to some of their non-legal interests. For example, their need for an apology or their need for validation of their self-worth. So I think whenever we're dealing with issues that are quite central to our identity as humans, including where we live, our employment, our health, and so on, those are extra reasons to be really mindful of the psychological part of the dispute and also the ongoing relationships, which may have to endure depending on the employment relationship afterwards. So those are my thoughts just to get the conversation going, and I'll hand it back to you, Mark, and sorry to Maggie.
Thank you very much, Shannon. Very interesting presentation. Daniel, maybe you have a first reaction on what was presented. I know you're a very, very experienced ODR aficionado. So if you can say a few words on what we just presented.
Yeah, and I'll be brief because I know we want to get to some of the questions that you prepared and also some of the questions from the audience. I would say to start out with that how one defines ODR is important. I happen to be on what I would consider the liberal end of the spectrum of defining ODR. I happen to think that if you are doing any of the major functions that you have to perform as a third party, and you're doing those using information and communication technology, that you're somewhere in the world of online dispute resolution. We were sort of joking earlier about first encounters with ODR, and I had said that for me, it was in the 1980s when I helped set up a mediation between Cairo, London, and Washington using telephones and fax machines. I have a colleague, Jessica Carter, who is for many years ran the landlord-tenant mediation program in New Zealand, and she had 60 mediators working all on the telephone. And they would be very surprised to hear that they were not doing ODR if your definition was more restricted. So I think for me, the idea of ODR is this thing that we do as human beings, as third parties. It has some repeating functions. And for me, I've said this many times, that I think there are three things that we do over and over again. We manage communication among the parties. We help the parties understand and deal with information. And we help manage the dynamics, the human dynamics across the table. And it's not an accident that three of the major things that information and communication technology does is explode the number of channels we have to work with, give us vastly more sort of significant and interesting ways to deal with information, and it even helps us define what a group is and redefine what a group is in terms of proximity. So if those things are parallel, they almost have to influence each other. They almost have to affect each other. I just very quickly, I would just say that there's a tendency to look at, in the legal profession and in labor law, to look at the e-commerce example as sort of a guideline for how one would want to approach complex problems. And what I mean by that is, if you look at the classic e-commerce development starting in the late 1990s and running on through, it's pretty much the framework that we've talked about so far. It's bringing people together to negotiate. It's giving them information that helps them through algorithms and other things to move along a process, introducing a mediator if it's necessary, and then finally working your way down to some sort of resolution. That works terrifically in labor law if you're talking about things like grievance mediation, dismissals, discipline. It works terrifically if you're talking about arbitration of issues that have to do with contract performance. Where it breaks down a bit, in my view, is when you start talking about things like collective bargaining, where it's a fairly complex, long-term, multi-party discussion that has to go on and has to be controlled over a period of time in multiple channels. In that case, the e-commerce model breaks down, but it doesn't mean that ODR doesn't work, because there are just a multitude of ways that you can apply information and communication technology to that kind of complex negotiation. And that's the world that I come out of.
Thank you, Daniel. And it's a very interesting perspective here on the difference between individual labor disputes and collective bargaining. And I personally also think that, especially with the technology, the level of technology we have now, everything is possible in both situations. And I even know of projects that are developing in both spheres. Um, However, also one issue or one question that is often raised when we speak of ODR, it's to make sure not to improve access to justice, and it's very important in labor disputes, I think, uh, instead of using great technology, but at the end making it more complicated for employees or for claimants to access ODR, to access justice. So what should be avoided, maybe to avoid making it more complicated and hinder a little bit the access of justice instead of pursuing the great objective of improving it?
If I could start with that, because I want to give a shout out to Shannon. The the approach that they've taken to product development is so critical. One of the arguments that I've made in the venues that I've been working in is that we can create marvelous technology. We can focus on access to justice and creating this technology, but the fact that we create it doesn't mean that people are going to come and use it. So there are two factors there that I think are important. One is the one that Shannon really talked about, and that is make it friendly to use once you find it. But I think there's a step before that, and that is, if I just make good technology that's easy to use and I invite people in, the invitation has to be a real invitation. It has to be an effective invitation, because if I'm not sure what the numbers are in Canada and in other countries, but in the US, the estimate is that as much as 70% of the justiciable issues that arise never even see a lawyer, much less see court. And we're not going to pull that 70% in to an access to justice program unless we do a little bit more than make good technology. We're going to have to go out and give them a reason to be there.
Yeah, exactly. If I could just weigh in there, in our experience, and I know Parl has been a bit of an outlier in this regard, in our experience in British Columbia and other places I've gone to, if you set up a pilot using ODR and make it voluntary, it is almost doomed to fail, because the incentives are just not there based on human psychology for both parties to attorn to the jurisdiction of whatever the ODR platform is. One person, in our experience, will often veto the other person's ability to use an effective, expedient ODR platform, and so you do have to make it mandatory. But the wrinkle to that, or the thing that softens that, is giving people lots of choices about how to engage. So just because you have to use the service or the platform, the service or the dispute resolution body, doesn't mean you necessarily have to engage with it the same way, that you necessarily have to do everything online. And I would just also endorse Daniel's view about ODR. I think a lot of conferences I've gone to, and Daniel would have gone to many more, about this kind of gnashing of teeth about what ODR really means. And I don't think it really matters. At the end of the day, what matters is, are you providing services to the people to whom the justice system belongs in a way that they can readily engage with through an even playing field? And where that will lead you is, for the vast majority of people, they will choose online services. In the CRT context, 99.9% of people choose to use online services, despite the readily available mail and telephone-based services we offer. But you still have to provide other ways for people to engage. So I would just endorse the idea of making transformational projects mandatory, picking a dispute area that is relatively low stakes. It's not a coincidence we started with condominium disputes, because those are often over barking dogs and paint colors and things that really matter to the people who have them, but are not life or death issues, and then going from there.
Thanks, Shannon. And we could have here a very interesting debate on the pros and cons of mandatory ODR, but obviously we're not here for that. I just wanted to jump on from this. You and Daniel, you mentioned that technology is not all of the solution, and it has a different role depending on whom you speak to. But what is, in your opinion, the role of the mediator in this online dispute resolution question for labor disputes, which, as you mentioned, Shannon, are often more emotionally charged, and I would say, from a personal opinion, often require someone, a person, a mediator, a professional, to intervene, despite it being online or not.
Please go ahead, Shannon.
Well, in our world, the mediator is really the linchpin of the entire process. What you find in a lot of courts, and I say this with the most respect, is a very judge-centric approach to dispute resolution that says that the judge should do the deciding, all the processes should lead up to that decision by the judge, and to the extent that there are mediation or other programs, those are often viewed as speed bumps on the way to that judge, or as side tracks where you hop out of the process and come back in. And even in courts that do embrace mediation, there's often a view that the judge should be the mediator. All of that is not the basis for the CRT. Our view, based on the empirical evidence, is that what people want is not necessarily a day in court. And I know that's anathema to a lot of courts. What people want is not necessarily to appear before a judge. It is some of the time in some disputes, but what people want from our research is they want a resolution to their problem that they are actively having a say over, and it won't cost them a lot of money or take a lot of time. And so mediation is really, really effective from that perspective, but only if the circumstances are built around that mediation process to support it and give effect to it. And so that's why I said earlier, a lot of our tribunal members where the judges in our process are there to support the mediators, to issue non-compliance orders if people are not participating in good faith. And a lot of what we do is built around the idea that the magic happens at mediation. And frankly, a lot of the case management happens there too for cases that do have to go to adjudication. It helps to narrow the issues and make clear what's at stake. And it gives an opportunity for the mediator to manage the party's expectations. So I think it's really, really crucial. And a lot of the feedback we get from the public is very much around how good the mediators were at in an emotionally intelligent fashion, helping to resolve their problem. What do you think, Daniel?
Yeah, I come at this, my background, I'm not an attorney, I'm the only non-attorney here. I come at this from a communication theory and conflict resolution background. And the way I looked, and the way I think many of my colleagues look at the role of the mediator, is there are some human needs at work that we need to be transparent about and that we need to pay attention to. People want to feel safe and secure. They want to feel that there's an order, not chaos. And they want to feel that there's some self-worth, that they're being recognized. And so I think one of the goals that you have as a third party is to try to address those needs and to ask yourself about the technology. Is the technology that I'm about to use going to add value in one of those areas? Is it going to make my parties feel safer? Is it going to make them feel like there's a process they can trust? And is it going to validate them? Is it going to make them think that they're heard? And if you can answer that question, yes, then I think technology can handle just about any kind of case. And one of the things that we're finding in multiple venues is if there are things like in divorce mediation, family mediation, if there's abuse issues, or if there are other kinds of issues that make people uncomfortable being in the room together, whether it's a highly emotionally charged or whatever the situation is, that sometimes they'll actually be more likely to be able to reach a resolution and feel comfortable in the process if they're using technology that means they don't have to be in the same room with the other party. So there are many questions that you can ask, but they really center around, first of all, am I being transparent with the parties I'm dealing with so that they understand what they're getting into? And am I adding value to them? Am I making them feel secure? Am I making them feel like they're being valued?
About this point of feeling secure, in labor law, it could perfectly apply to harassment cases, sexual, psychological harassment cases, which are treated in Quebec by the CNESST. But that's a very good point, that when you are online, you don't have to meet in person. The other party would, in a harassment case, could be a very deciding factor. Maybe I would like, before taking questions from the public, I would like to hear perhaps maybe if you have a few advices on how to implement or how to encourage ODR in labor disputes, be it collective bargaining or individual disputes.
Shannon, after you.
I am, with the caveat that I am in no way an employment or labor expert, I would say that some of the things that worked really well for us in implementing the CRT was getting buy-in from the public, and certainly getting buy-in from community advocates who work in this area day in and day out. And so in the labor context, that might look like talking to employers, talking to unions, and talking to other stakeholders. But I would just give the caveat that it's really important to build ODR processes around the needs of the public, and not instead to do what a lot of jurisdictions do, which is to gather together a group of lawyers and judges and IT professionals and court administrators, design something, build something, and then say to themselves, well, we will scale up or down to meet the needs of other users. If you do that, you're going to end up like something very much like what we already have. And so what's necessary is to do something fundamentally different and talk to the experts in that area. Those experts will be different depending on the subject matter. In the labor and employment context, obviously talking to employees is important, and talking to employers and figuring out what's going to work for them, and then validating that as much as possible before doing the work to validate it with lawyers and other justice stakeholders. I think, unfortunately, we get a little bit of problem blindness in the justice system, and that's a well-documented phenomenon too. We can't see the issues that we're surrounded with when we're so embedded in a system, despite our commitment to access to justice. So get outside of that bubble and start working with those stakeholders, get buy-in, get them to start lobbying for change as well, and build a coalition that will help you develop something that will be so, I think, have its own entropy so much that it'll be very hard for more entrenched interests to resist. On the flip side of that coin, I would say that the biggest issue we've had with the CRT is change management with entrenched justice stakeholders. So many lawyers in British Columbia are big advocates of the CRT, but there are some corners of our legal system where there's been a lot of opposition, despite widespread public support and satisfaction. And so you're likely not going to be able to persuade somebody whose living depends on status quo that it should be changed. And so my suggestion would be, again, not to focus on that area of stakeholders, and instead to go to the people who would be using it and count on their advocacy as well. That's a bit of strategic advice. Daniel, do you have anything to add to that?
Yeah, I would say that outside the first of all, I agree with what you just said, and you're dealing with a system that is really trying to bring in as many people as possible to handle those disputes in a way that is not only efficient but fair, et cetera, et cetera. And that's one sort of side of the labor law thing. The other side that I'll sort of go to that's on the other end of that is that something like collective bargaining, or where you have fewer cases but more complicated long-term cases with multiple parties, et cetera. I think the way you encourage that, well, first of all, I have a colleague who's made the comment that we're in CNN, crisis new normal. And that is that, people have been forced to use technology in ways that they never would have used it if they hadn't been in the middle of this crisis. His argument is that we're going to go to NNN, normal new normal, after we're all through with this. And what's going to have happened is that we're going to have been sort of velocitized, so to speak, to the use of technology. It's not going to seem so weird anymore. But what I would say in response to the question is, if you really want to encourage the use of ODR technology in complicated cases, first of all, learn yourself what's available and what you can do with technology that you can't do face-to-face. The question parties are going to ask you is, what's in it for me? Why am I doing this? Literally, what's in it for me? And if you can say to them, okay, if we use this technology, these are things that we can accomplish that would be difficult or impossible to accomplish face-to-face. We've never had a problem with the parties being a barrier. It's the practitioners who are the barrier. The parties will look at that and say, oh, I see the value in that. Yeah, let's do that. So I think the first step is to educate yourself about what value you can add by using the technology.
Thank you. So the practitioners are being fired at, and I totally agree, and it's a very often raised issue in the discussions about ODR. I see there are questions popping from the public. Maggie, maybe we can take some of them right now.
Sure, sure. We do have a lot of questions. So I'm going to start with the first question from Hannes Westerman. Do people behave as you initially expected in the connection with the ODR systems, or were surprised by how people use platforms?
Daniel, do you want to start with that? Or Mark?
Go ahead, Shannon.
Okay, there were a couple of things that surprised us. One was that based on our research in 2015, when we were about to open, we thought about 10 or 15% of people in BC would use offline services, so mail, telephone, and we thought that's pretty good. That's great, we can definitely handle that. One thing, as I mentioned, that surprised us is how few people actually are. In part, that's because the growth of internet adoption, even in 5 years, has changed, but also because a lesson that we've learned is that if you can design your technology to look like buying something on Amazon or navigating through Facebook or Instagram, most people will choose to do that rather than even go to the mailbox and figure out how to find a stamp around their house. And that's even more so now. So before the pandemic, 99.9% of people were using online services. And I think besides design, easy design, a key piece of that is making it really easy for helpers, so that if you are somebody who is not comfortable with technology, you want to make it really easy for that person's neighbor or friend or son and daughter to sit on the couch with them after dinner and fill out the form with them online on their smartphone. You don't want that person to have to take a day off work and go down to the courthouse to be able to support their friend or family member in navigating the court system. So I think that was one thing that surprised us. The other thing that has surprised us is how much people have really embraced this and how much public support and community legal advocate support it's had. But I think, again, that's a reflection of human-centered design, using an agile development methodology that has you go out and test constantly and never stop, and stay really glued to people.
Colin Rule and I had a conversation some time ago in which we sort of came to the conclusion that manuals are for losers. If your software is complicated enough that you need a manual, it's too complicated. You got to start over.
The same could be said for court rules, arguably. If you need to look at court rules, you're probably doing something wrong as the provider.
Yeah. The thing that I would say, just to add to what you said, Shannon, is that there was an expectation early on that the distance one has when using online tools would mean that you're going to engage in more flaming behavior and bad behavior. What we tended to find actually is that if somebody makes the commitment to say, I'm going to join this virtual room in order to accomplish this thing, that they tend to focus on that, and actually the bad behavior has really not been a factor at all. So if you can get them in, they generally are pretty effective.
Just to jump in, I completely agree. I used to hear that all the time. But the difference between commenting on a newspaper article in a horrible way and engaging in our process is it's not anonymous. And there are consequences for doing that. But I also think you're right that a lot of that is cultural, in the sense that if the culture within the tribunal or court or platform is one of respect, or where the standards are clear, that tends not to be so much of an issue.
Thank you. I will go with another question. How has been the migration of all the tribunal to the home office experience during this pandemic time? What was the challenge to it?
Is that directed at me? Or?
I think that would be
me. Okay.
I think so, yeah.
Tribunal. Well, we were really in a good position before this started because we were predominantly remote. So all of the tribunal members and the mediators always have worked from their home. I've been here for 6 years. Feels like longer the last couple of months. But we do have some frontline staff, the equivalent of a court registry staff, who were in offices. But in late February, early March, we kind of saw this coming over the horizon and pivoted them to work at home as well. So the consequence is that we haven't skipped a beat. And as I say, we're one of the only places offering civil dispute resolution within the public justice system that's remained open. And that's allowed us to really focus on how we can help parties. So we're not just trying to keep our doors open, that was fine, but we know parties are having financial problems. We know parties are having need extensions of time, for example. So that's what we've been able to offer in terms of help to people. And I like to say too that part of the reason we were able to maintain services during this time isn't just that we're remote, it's that we were designed to be able to help and accommodate people who are facing financial hardship, who don't have easy access to childcare, who can't travel to a courthouse easily, who don't have access to legal services. And it just happens that if you design a tribunal or a service around the people with the most barriers, what happens in a pandemic is just that the vast majority of us are getting a taste of that. Not at all to equate having to work from home to the situation of somebody who's in dire financial straits, but we're all one way or the other being impacted by COVID, right? In terms of less financial resources, more precarious employment, limited access or no access to courthouses or in-person services. And so again, an endorsement for human-centered design. If you build the justice system around the people who have the most barriers, then when the pandemic or something happens that just increases those barriers for everybody, you're already in a good place where you're able to adapt.
Thank you, Shannon. Maybe a question for Daniel. What is the future of online dispute resolution post-COVID-19?
You know, every time, most of the people I know, every time somebody asks a question like that and we make a prediction, oh, within 6 months or so, we're sort of going, I wish I hadn't said that. So, but I do think that there's a process of being acclimatized to online dispute resolution tools that has been accelerated greatly by the COVID-19 virus. We saw for a decade or more sort of slow progress in integrating technology into various kinds of dispute resolution systems, including the courts. And all of a sudden, overnight, everybody has to use it. Now, I'll just use, again, I'll go back to my other example. This is going to, eventually we're going to go back to work in some fashion or another. There are going to be a lot of layoffs. There are going to be a lot of dismissals. There are going to be a lot of issues about when is it safe to go back, and can I tell my employer I don't want to go back or work in that condition. And we can't wait until that happens to handle how we're going to deal with those issues. And so unions right now, and the lawyers who are working for the unions are working with lawyers in the companies to say, okay, let's get ready for those issues because they're coming. The fact that we're having to do that means that we're getting used to using technology in a way that we haven't used it before. A few years ago, I was teaching an ODR class at a university in the US, and I was talking to one of the students there who had gone to the airport to pick up another speaker who was coming to the university. And his topic was how to deal with intractable conflict or intractable opinions in a conflict. And when she said, I'm taking an online dispute resolution course, his first comment was, oh, that'll never work. And so my comment was that he obviously understands about intractable positions. But that was not an uncommon attitude that, you know, this just won't work. You know, face-to-face is the gold standard. We have to be there. It just won't work. And I think what we've proved over the last couple of months is, well, it does work. We were proving it before, but everybody's getting a taste of it now. I guess I say all that to say that I think we're not going to go back to where we were before. I think there are two things that are going to happen. Using technology is going to become more pervasive. And I think as we move forward, we're going to be seeing more and more algorithmic driven and AI driven assistance in mediation available to private practice mediators than we've had before. So that's my prediction.
Thank you. I have a question, maybe more for Shannon. Do you sign settlements the same day or later via email?
It's an asynchronous process usually. And so what will happen or can happen is one party will make a settlement offer, another party will have 48 hours to consider it or some longer period of time and then come back into the process. So there's an odd kind of dynamic with ODR where on one hand, we massively collapse the administrative delay for our side. We're resolving contested small claims disputes in under 57 days now as a median. And these don't include defaults. These are contested ones where both parties are participating. And the way we do that is aggressively automate any business processes, reduce delay on our side while giving the parties time. And so in the mediation world, what that means is instead of having to be at a courthouse or a boardroom somewhere for an hour where the mediator says go and you have that constricted time, we can stretch it out a little bit. We can give people a couple of weeks of going back and forth, getting information, getting legal advice if they want to, talking to a spouse, sleeping on it, reflecting. And so it's this odd thing where it's both much faster and more efficient, the whole process, but it's also slowed down because we want people to think about it, to think before they respond, to carefully consider their options and get the advice they need. And I think all of those are real advantages in addition to what Daniel said about not having to be in the same room or see the person who you're so upset with, or maybe even a little afraid of in some circumstances as well.
And if I was going to only add to this, to say that the Parl platform works a little bit like Shannon mentioned, it's asynchronous, and just the same, it helps reduce, well, for the consumer protection Parl, it helped reduce like by 12 times the costs of a usual small claims case, if I would. And the goal here, when you offer a platform to the user, to make, like Daniel mentioned, it has to be simple and user friendly. So even the signature process, it has to be automated, but we take good care to explain the consequences of clicking yes or putting an electronic signature on an agreement when that happens.
Thank you, Mark. And the last question, does ODR lower the threshold for conflicts to be pursued by the parties? Is this a good thing? So you can all answer one by one if you want to.
Yeah, Shannon, I think that's a good one for you.
I was waiting to hear what you would say about that, and Mark, but I'll turn it over to you in a second. That's the thing we heard a lot before we opened our doors. If you make it so easy for people, you're going to have the floodgates open and all these petty, unmeritorious claims will come in. It's just not been the case. Our levels of small claims particularly have increased a little bit. For the condominium disputes, it's true that we get about 600 of those a year, and the courts weren't getting very many at all because that was so complicated and expensive. But my answer is always this, which is that it's our job to make sure that the public justice system is accessible to everybody. And yes, if you tear down fences and barriers, everybody will be able to hop over. That is a small price to pay in order to increase access to justice for the 70, 80, 90% of people who frankly have no access to the system at all in order to enforce their legal rights. And that's not to say that you allow everybody to run roughshod over the process. We have ways of identifying vexatious and frivolous disputes. We charge a fee, an application fee for service, which is a deterrent to just filing 200 disputes. That said, we have a very generous fee waiver process for people with a low income. And what we've seen, like so much else in our justice system, is that some of these fears are things we tell ourselves to justify processes which are very inaccessible, but which are not at all backed up by any empirical evidence. So there's no evidence to support a floodgates argument. And in fact, we're demonstrating good evidence that you can make the process so dead simple that you can do it from your phone on your couch and you still won't be inundated. And so how do we justify these inordinately burdensome, complex processes that we use? Another example of that, and I won't go on this rant because we don't have time, but the fee waiver process courts use across North America is massively burdensome to justify abuse, which, like voter fraud, is a thing that people talk about but doesn't actually exist empirically. So I would just encourage us to take that lens to everything we do and think about what is the empirical evidence to support the way we're doing it. Sorry, Daniel and Mark.
Well, I would just say that I agree with what you said, and I think the basic issue that you have when you ask a question like that is that we really don't have any long-term data. But the data that we have that would be observational data would say that the problem is getting more people in, not turning people away once they get there. So it's the opposite end of the stick, really.
Yeah, and obviously I couldn't disagree with what you both said. And I think there's really a question of weighting here, the abuse versus the access to justice, facilitation. And that could be said also of, of the jurisdictions who who simplify processes for small claims, the same argument could be made that, oh, well, if you do that, you're going to lower the threshold and it's going to be abusive. But I think at the end, it's important for access to justice. And like Shannon mentioned, it's not, and even Daniel agreed with, it's not empirically demonstrated or even studied of what I know.
Well, if I can give you another comment from the fringe, I would say that the problem with abuse of the access to justice issue is not on people who can't afford to get in, who suddenly are going to flood the system. It's from people who have enough money to game the system and use it as a club against people who don't have enough money to defend themselves. So yeah, I don't, if we open the floodgates and we have more people that we can deal with, that's a problem I would love to have.
Thank you, Daniel. We will end this webinar. So thank you to our panelists. Thank you very much. And thank you to all the participants present today. Stay tuned for our upcoming events on our online website.